Welcome back to the Deep Dive. Today, we are wading into some pretty murky waters. We're tackling a concept that sounds incredibly simple on the surface, just asking a question. But it turns out, depending on what you ask and maybe how you ask it, mere words can land you in prison for a very, very long time. We are looking at the crime of asking.
Precisely. And it's a fascinating area of law because it challenges our basic intuition about what a crime even is. Usually, we think of a crime as, an action that causes some kind of visible harm, stealing a car, breaking a window, something like that.
Right, something tangible, something goes snap or something goes missing.
Mm.
But here, we're just talking about speech. I mean, if I turn to you and say, hey, you should really go rob that bank, and you look at me and you're like, you're crazy, no way. Have I actually broken the law?
Yeah.
Or what if I write a letter to hire a hitman, but the post office loses it?
Yeah.
Is that a crime, or is that just like a really bad diary entry that got away?
Yeah. It is absolutely a crime. And that is exactly where we're going today. Our mission here is to master the legal mechanics of criminal solicitation under the Model Penal Code.
Okay, let's unpack this, because we're not just talking about, peer pressure.
Huh?
We're talking about felonies. And I know our listeners want to get into the weeds, so we're not just going to chat about the general idea of being a bad influence. We're going to build a diagnostic tool.
We are. To surely get this, we have to be rigorous. We're going to dissect this using 3 distinct doctrines from the Model Penal Code. First, we'll look at the strict definition of solicitation, and we'll break it down element by element.
Okay.
Second, we'll tackle the tricky concept of uncommunicated solicitation, what I kind of call the failed attempt scenario. And finally, we'll look at renunciation, the is it too late to turn back defense.
Oh, I love a good defense. It's the redemption arc of the legal world.
It is.
So the goal here is that by the end of this deep dive, if you see a messy situation with some sketchy request, you can spot exactly where the legal liability lands.
That is the goal. We want to move beyond just it feels wrong and build a precise element-by-element framework you can actually use.
All right, let's dive in. We have to start at the foundation. How does the Model Penal Code strictly define this crime? Because solicitation sounds so polite. It sounds like someone coming to my door to sell cookies, not hire a hitman. What's the actual black-letter law here?
Yeah, it's definitely not about cookies. The general rule is from MPC section 5.02. And it says that a person is guilty of solicitation if, with the purpose of promoting or facilitating a crime, they command, encourage, or request another person to do something that would be a crime.
Okay, that's a mouthful of legalese. Purpose of promoting specific conduct, command, encourage, or request.
It is, but we can simplify it. We can break it down into 3 testable elements that you can apply to any set of facts.
Okay.
First, you have the mens rea, the mental state, which here is purpose. Second, the actus reus, the physical act, which is that commanding, encouraging, or requesting. And third, the object, the thing you're asking them to do, has to be a crime.
I think the best way to make this stick is to stop talking in the abstract and see it in the wild. I've got a scenario for you.
Okay.
Imagine a high-stakes kitchen. Super stressful, pans clanging, steam everywhere. Let's call this the rival chef.
Set the scene for me.
So Chef A is just insanely jealous of Chef B. Chef B is getting all the press, all the awards, everything. And Chef A just snaps. He pulls a waiter aside into the walk-in freezer, hands him this small vial of arsenic and whispers, I beg you put this in Chef B's soup tonight when I'm gone.
Wow.
The waiter looks at the vial, looks at Chef A, and immediately says, absolutely not, you're a lunatic. He throws the vial in the trash and walks away. Chef B eats his soup, loves it, goes home happy, no harm done.
A classic setup
Yeah.
and a perfect test case for the rule.
So let's analyze this. What are the legally dispositive facts here? What actually matters?
Okay, so we have to filter out the noise, the clanging pans.
Yeah.
The essential facts are these. First, Chef A has a specific intent. He says, I want him gone. Second, he does an action. He hands over the means, the arsenic, and he makes a verbal plea, I beg you. And third, critically, the request itself is to poison someone, which is a crime. And, of course, the waiter refuses.
And the core legal issue seems pretty obvious. Is Chef guilty of solicitation, even though the waiter said no and absolutely nothing bad happened?
Exactly. The issue is whether the crime of solicitation actually depends on the other person agreeing.
So let's apply that rule you mentioned, -MPC 5.02. Walk us through the elemental analysis. Because if I'm Chef A's lawyer, I'm arguing, look, nothing happened. He was just venting in a freezer.
And that defense would fail hard. Let's look at the first element, the mental state. The rule requires purpose. This is the highest level of intent in the Model Penal Code. It means it has to be the actor's conscious object to make the crime happen.
So just being reckless or negligent isn't enough.
No. If he just jokingly said, ugh, I could kill that guy, that's not this. But here, Chef A says, I want him gone, and he hands over a vial of arsenic. Those facts show that his purpose was to facilitate the poisoning. He wasn't joking. So the first element is definitely met.
Okay, that makes sense. The arsenic kind of seals the deal on the whole joking defense. What about the second element? The actus reus. You said it was command, encourage, or request.
Right, and the model penal code is very broad here. You don't need to order someone like a general. A simple request is enough. In our facts, Chef A says, I beg you. That's a clear request. He also says, put this in the soup, which is encouragement, maybe even a command. The statute only needs one, so the act of asking satisfies this element.
But the waiter said no. I mean, doesn't that matter?
For the actus reus of solicitation, nope. The crime is the asking. Whether the waiter says yes, no, or runs to the police is totally irrelevant to whether the solicitation happened. The door was open.
Got it. And the third element, the specific conduct.
This element just requires that the solicited conduct would be a crime. Here, the conduct is putting arsenic in soup. That's murder, or at least attempted murder. It's objectively criminal, so this element is met.
So after analyzing all the elements, what's the final conclusion?
Chef A is guilty of solicitation. The waiter's refusal is legally irrelevant to Chef A's liability. The crime is complete the moment that ask is made with the right intent.
That's fascinating. It's like the law sees the ask itself as a virus. You're putting it out into the world, and that act of contagion is the crime, even if the other person has a strong immune system and says no.
That's a great analogy. The MPC focuses on the danger of the actor trying to recruit others into crime. He's shown he's dangerous, and the law wants to neutralize that danger immediately.
Okay, but this is where it gets really sticky for me. In the kitchen, they were face-to-face. The waiter heard the request. But what if the ask never actually arrives? What if the solicitor speaks, but the other person never hears it?
Now we are moving into the territory of MPC 5.022 quest. This is the rule for uncommunicated solicitation.
Give us the black-letter law on this.
Yeah.
Because my gut says if nobody hears it, it's like a tree falling in the forest, right? No crime.
Well, your gut might be surprised. The rule states, it is immaterial that the actor fails to communicate with the person he solicits if his conduct was designed to affect such communication.
Designed to affect such communication. Okay, that sounds like a really specific phrase. It shifts the focus completely onto what the solicitor tried to do, not what actually happened.
It does. It's all about the actor's effort.
Let's test this, because I'm skeptical. Let's look at a hypo. Let's call it the prison letter.
I'm ready.
Okay, so you have an inmate. He's stuck inside, but he wants a witness on the outside to be intimidated. So he sits in his cell and writes a very detailed letter to a hitman he knows. He offers 10 grand to burn down the witness's house. He puts the letter in an envelope, addresses it, stamps it, and places it in the official outgoing mail bin at the prison.
So he's done everything he can possibly do from inside.
Exactly. But the prison guards are checking the mail. They see the letter, they open it, read it, and they confiscate it. The letter never leaves the facility. The hitman never sees it, never even knows it existed. The communication failed completely.
This is a textbook example for Section 5.022.
So let's analyze the facts. We have the drafting of the request, the physical act of stamping and mailing, and then the interception, the total failure of reception.
Correct.
And the issue is, does that interception save him? Can he argue, hey, nobody heard me, so I didn't solicit anyone?
That's the argument he'd make. But let's look at the rule, MPC 5.022. It really has two parts. First, we look for conduct designed to affect communication. Second, the rule says that if that design is there, the failure to communicate is immaterial.
So let's do the elemental analysis. How do we apply that first element, conduct designed to affect communication, to a letter just sitting in a bin?
We look at what the inmate did. He didn't just write the letter and keep it under his pillow. He stamped it. He placed it in the official outgoing mail bin. That act, in that context, is conduct specifically designed to get a message to someone else. It's the final step he can take to start that process.
He let go of it. He surrendered control of the message.
Exactly. So his conduct meets the standard of being designed to affect communication.
Okay, but I still have to push back on the second element, the failure to communicate. You're telling me it really, truly doesn't matter. The hitman is oblivious. The witness is safe.
This is the so what element. The rule just shuts that argument down. It says the failure is immaterial. That means the judge and jury are basically instructed to ignore the fact that the hitman never saw it. Since the first element, the design to communicate, was met, The second part of the rule kicks in to preserve liability.
So the final conclusion.
The inmate is guilty of solicitation. Under the MPC, the crime is crystallized in that attempt to persuade. Whether the letter is read by the hitman or shredded by a guard, it just doesn't change the inmate's criminal culpability.
Wow. That feels incredibly strict. It really reinforces that idea that the law is punishing the evil mind or the dangerous will more than the actual result.
Precisely. You have shown how dangerous you are. You tried to launch a missile. The fact that the missile fizzled on the launch pad doesn't mean you aren't a person who tries to launch missiles.
Okay, so we've established the law is very harsh on starting this process.
Yeah.
But is there any way out? Let's say I ask someone to commit a crime or I send that letter, but then I wake up the next morning and think, oh my God, what have I done? Can you undo it? Or is it like pulling a trigger? Once it's done, it's done.
This is where the Model Penal Code offers a path to redemption. And honestly, it's good policy. We want people to change their minds. We're talking about the affirmative defense of renunciation under MPC 5.023.
Walk us through the rule. What does someone actually have to do to earn this kind of legal forgiveness?
The black letter law says it's an affirmative defense if the actor, after soliciting someone, persuades them not to do it, or otherwise prevents the commission of the crime. But, and this is the kicker, it has to be done under circumstances that show a complete and voluntary renunciation of their criminal purpose.
Okay, there seem to be two heavy lifts there. You have to actually stop the train, and you have to do it for the right reasons.
Correct. It's a very high bar. You can't just, say, my bad, and hope for the best.
Let's see if we can find a scenario where this works. We'll call this one the change of heart.
I'm listening.
Imagine a wealthy heir. He wants his inheritance now. He pays a shady mechanic to cut the brakes on his father's car. The deal is done. Cash is handed over. The mechanic is on his way. But an hour later, the heir is just overcome with guilt. He realizes he actually loves his dad. He panics.
The conscience kicks in.
Big time. So he runs back to the garage, bursts in, literally pushes the mechanic away from the car just as he's about to cut the brake line. And then he physically fixes the line himself before his father can drive it.
That is a very dramatic turnaround.
So let's analyze the facts. We have the initial completed solicitation, then we have the emotional shift, the guilt, then the physical intervention, pushing the mechanic, fixing the brakes, and the result, the crash is prevented.
And the core legal issue is whether the heir can use this renunciation defense to get out of the initial solicitation charge, given that he definitely committed the crime, but then he stopped it.
So apply the rule. MPC 5.023. Break down the elements of this defense for us.
Okay. The rule requires proving two distinct elements. First, there's the action element. The actor has to have either persuaded the other person to stop or otherwise prevented the crime.
Okay.
Second, the motivation element. This has to be done in a way that shows a complete and voluntary renunciation of criminal purpose.
Let's do the elemental analysis. How about that first element, prevention? He definitely prevented it, right?
Yes. The rule offers two paths here. You can talk them out of it, persuade him, or you can stop it yourself, otherwise prevent it. In our facts, the heir didn't just ask the mechanic to stop, he physically intervened. He pushed the guy and repaired the brakes. This clearly falls under otherwise prevented. He was successful. First element is met.
Now, the second element seems like the tricky one, the motivation. Was this a complete and voluntary renunciation?
This is where we have to scrutinize the why. Why did he do it?
Well, the facts say he felt guilty and realized he loved his father.
And that's crucial. That tells us the change of heart came from his own conscience. Compare that to a scenario where he hears police sirens coming towards the garage. If he stops because he's afraid of getting caught, that is not voluntary.
Right.
Or if he stops because he finds out his dad is already broke, that's not a complete renunciation. He's just postponing it.
Right. I'll just kill him next week isn't exactly renouncing the crime.
Exactly. But here, the facts show a genuine abandonment of the criminal goal, and it's driven by guilt. So it was both complete and voluntary.
So what's the final conclusion here?
The heir has a valid affirmative defense under MPC 5.023. Even though he absolutely committed solicitation in that first hour, his later actions can wipe the slate clean, legally speaking. He should be acquitted.
It feels a little weird that he gets off scot-free after, essentially paying a hitman. But I guess I see the logic.
Well, think about the incentives. If the law said, too bad, you solicited him, you're guilty no matter what reason does the heir have to run to the garage? He might as well just let the car crash. By offering this defense, the law encourages the solicitor to go undo their own mess. It saves the father's life.
That makes perfect sense. It's practical. It values the life of the potential victim over the punishment of the solicitor.
Exactly.
Okay, we have covered a huge amount of ground today. We have the definition, the uncommunicated letter, and the way out with renunciation.
We have.
For the listener who's maybe prepping for an exam or just wants to be the smartest person at the table, let's zoom out. Give us the cheat sheet. How do we spot this and solve it every time?
Okay, if you're looking at a fact pattern, just use this step-by-step diagnostic checklist. 4 steps.
Hit me with step 1.
Check mens rea. Did the actor have the purpose to make a crime happen? If they were just joking, just venting, or being reckless, it's not solicitation. You need that specific goal.
Step 2.
Check actus reus. Did they command, encourage, or request? Look for those verbs. And remember, the rival chef, if the other person says no, it doesn't matter.
The asking is the crime.
The asking is the crime. Step 3,
Go ahead.
check communication. If the message didn't arrive, like our prison letter asked, was the conduct designed to deliver it? If they stamped it, mailed it, hit send, whatever, they're liable. Under 5.02,
And the final step.
check defenses. Did the actor have a genuine change of heart? Did they successfully stop the crime? And was it voluntary or just because they got scared? If it was voluntary and successful, you apply renunciation under 5.023.
That is exactly what we needed. A clear roadmap. You know, what stands out to me from all this is just how powerful words are in the eyes of the law. We all grow up hearing, "Sticks and stones may break my bones, but words will never hurt me." The Model Penal Code really disagrees with that.
It definitely disagrees. The law recognizes that words are the spark. And if you strike the match, you're responsible for the fire, even if a gust of wind blows it out before it catches.
Thanks for diving deep with us today.
Always a pleasure.